hiring, layoff, and firing practices. This is a complex topic. How does a company appropriately and legally extend job offers in this environment? Can companies require testing of applicants? Can they require testing of returning employees? This has been a big, big question for the last few months, and it's now been answered because of all bodies of government, the Equal Employment Opportunity Commission, within the last 2 weeks, has opined that as long as companies are doing it fairly and consistently, they can require testing of applicants. They can say, we're going to condition your job offer on you getting a negative test result. They can ask people to stay home for X number of weeks, even as an employment applicant, and say, we're going to start your job May 15 or June 1st. And importantly, they can require testing of existing employees, including people who have been off the job and are going to be returning to the job. So this is extremely important for people to know.
May I ask a question that came up in the chat box? When you are going back to work or offered employment, are you responsible for paying for a COVID-19 test yourself, or is the employer who is demanding that be a requirement responsible for paying for that test? And how would somebody go about getting it? Whether it is, you know, if the employer is not providing it, would they go somewhere for that? Do you know?
So these are great questions. One of the earlier ones than that, a predecessor question would be, how's the employer going to make sure there are test kits available? What facilities are they going to be using and asking people to go to? It's my belief, I don't have any other basis for saying it, is that if an employer is requiring a test, they should be paying for the test. But again, that's my belief, you know. I mean, if they say you have to go for a fitness for duty exam, you're going to their expert. You can get your own. Like if you go to their test person and you get a positive result and you want to check that, you can go get one yourself, but you're going to pay for the second one. So in addition to that issue, which is a really important issue, that's why we had to start with that, employers are allowed to withdraw job offers to applicants who have COVID-19. The bottom line is employers have the obligation to protect the safety and well-being and health of all employees. And so therefore, that's why this break in what we would call previous law has occurred. If an employer has legitimate concern about an existing employee, a returning employee, or a new hire, they can require the employee to remain off-site or delay a start date, as long as the practices are consistent with company policy and are consistent and non-discriminatory regarding these things. Notwithstanding that, we're expecting that there will be many employment claims by people saying this was not fairly administered and it's not right.
So what does that mean overall, Hanan? You have the employer side saying one thing, and you're saying that the courts might say something different. So where does that leave a job seeker who is struggling to pay bills and get a job?
Well, actually, I didn't say that the employee would necessarily win, but they can make the claim. And the thing is, they might win, because I'll tell you, this is what I can see happening. You know, John is standing there and watches Betty Lou sneezing into her sleeve repeatedly and goes to the immediate manager and says, I think she's symptomatic. I'm scared. I'm going to walk off the job. And I see Bill and you know, Arlene over there thinking the same thing. And manager goes, all right, it's 4 of them against 1 of them. And so, you know what, I'm putting you out on leave, and then I'm sending you a notice saying you're not coming back, right? That may be the wrong way to handle it, probably is. So what I'm saying is, in theory, if the employer does what the EEOC permits and there's a positive result and they say to somebody, you're not coming back, or somebody who was out and comes back and has a positive test, or an applicant, in all those cases, the law has changed. It now says you are free, as long as you do it in a non-discriminatory way, to have that person not start, not be hired, or be fired. When returning to work, employers are allowed to require workers to submit doctor's notes certifying fitness for duty, according to the EEOC, citing guidelines of the Americans with Disabilities Act. Now, basically, my example would be this. Suppose we have a village on the edge of the ocean, and that village has, places of worship and schools and houses and roads. It has all the infrastructure. And a tsunami comes along and washes everything out, puts everything under 10 feet of water. Okay, the law is the village. The infrastructure is everything that was there before the tsunami hit. So what we now have is this tsunami on top of the law. And there's going to be an adjustment period, just like happened with the EEOC. But that's not the only law. We have many laws that are, involved in this. There's the Americans with Disabilities Act. There's state law. There's the New Jersey Law Against Discrimination, and there are anti-retaliation laws. There's HIPAA, right? How about this? You must tell your employees, for safety's sake, there has been a positive result from an employee. And we're telling you this in case you were exposed. A, are they allowed to say the name of the employee? The answer is no. Under HIPAA and the ADA, the answer is no. B, can they ask the employee to voluntarily release their name? Yes. And the employees oftentimes are willing to, because if there's been an exposure, they want people to be protected from that individual, right? So these things need to be integrated and put together. And what we're basically in is an emergency. Even still, I was mentioning to my wife yesterday, unlike a flood or a fire, we can't see it, but it's having a devastating effect, and we have to take it all into consideration.